Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group and has spent more than 40 years defending people charged with serious state and federal crimes across California. He's personally handled thousands of felony cases and is known for his strategic, no-nonsense approach when the stakes are the highest. I'm Evan Mack, and today we're answering a common question. Can felony charges be dropped before trial? And if so, how in the world does that actually happen? Robert, sir, welcome back.
Welcome. Thank you for having me.
Absolutely. Rob, listen, when someone is charged with a serious felony, is it realistically possible for the case to be dismissed even before trial?
Oh, of course. I've had that happen before. I mean, I'm not going to say I've had it happen many times, but as you work up a case and you have an investigator and you find witnesses, you present those witnesses to the DA, and normally you have to work yourself up the chain of command to do that. And they look at the evidence and they'll decide whether or not you're right or you're wrong. But there's a tricky slope. It's a slippery slope there, because on the one hand, you want to get this case dismissed for your client, but on the other hand, you have to weigh whether or not you want to give this evidence to the DA before trial, because they don't have it. And if they don't dismiss your case, now you've given them, some evidence that perhaps they could prepare for before trial and try to figure out a counter to it. So, you got to think about that before you do it. What are the likelihood that you'll get it dismissed? Now, when you have a sex case, okay, like when we were talking about, can you get a serious case dismissed before trial? In my mind, I'm thinking homicide, federal case.
Right.
Like I've had federal cases dismissed the Friday before the Tuesday trial because I've presented them evidence and they went, yeah, you're right. The feds way back when I did that are much different than they are now. I mean, they're a different office right now. So I don't know where that would go. But what I'm thinking of is a rape case. So a rape or some sort of a sexual assault kind of a case. And even if you have really, really compelling evidence to dismiss the case, it's very difficult for the DA's office in a rape case just to dismiss it before trial, because they got to call this victim and kind of explain, life to them. Look, they have this, you're going to look bad, So a lot of times a sexual assault victim will say, no, I want my day in court. That's right. It. No, this person did it to me and I want my day in court. You shall have your day in court then. Mm-hmm. And that's what happens. So
what are the most common reasons, though, these felony charges can get dropped or reduced early in the case? What are kind of the circumstances that you've seen?
It's not the right person. I had one, like when we're talking about, I'm thinking of one federal case in particular where I guess the feds were tipped off to a really major drug sale that was going on. It was like truckloads of drugs, and they were to meet in this parking lot. And so the DEA had intercepted everyone. And when they grabbed the cell phones of all the participants, they have this one person who is directing everybody, and they don't know who that is. They tried to go backwards. Okay, who owns this phone? And then they were able to figure out, well, the phone came from this location, which happened to be in a county nearby. I mean, not nearby the location, but in Southern California. And they were kind of narrowing it down to anyway. So what happened in that case, I actually hired so they got the wrong guy. I mean, they think it was this client. So I actually hired a specialist. This person listened to the tape So it was all in Spanish. So I had gotten like a translator to translate and a voice specialist to listen to this tape of this guy. And it turns out that when you compare a voice comparison person, so they compared the voice on the actual tape recording to my client's accent and the way he spoke, and you could tell it's like it was a different type of Spanish that they were speaking on the tape. In other words, if you listened to me speak right now, well, I don't have a Southern twang like you might find in Texas, or you might find even, in the South somewhere. Even in the South, there's different, you could tell, okay, you're from Alabama, you're from Texas. Well, this guy, what the point is this, the accent that was on there was like, well, no, this is Cuban. This is a Cuban accent. And my guy was from Mexico originally. And so that's one piece of evidence that, I can go on. You want more?
Hey, listen, I want it all, Robert.
Okay. Well, how about this? How about coming up with people who were at the shooting scene, and they were able to testify from their observations that the so-called victim who was killed had a gun himself, and he was in the process of pulling it out. So, those are things that, that's self-defense. That would be self-defense evidence. So if a jury hears this, they're going to do the right thing and acquit your client. In the federal case that we were talking about, when they hear that, wait, this guy's the dialect, and he would be able to explain why the dialect, it's not even sounding like the same guy. The disappointing thing about when I talk about that case, which was a federal case, and I had gotten a voice recognition expert on it. I couldn't remember that before. A voice recognition expert who spoke Spanish. Even after, I had presented this, and the boss of the U.S. attorney at the time said, "You're right. Okay, we're going to dismiss the case." The U.S. attorney who was assigned to the case had revealed to me, I had a counter to that. I had a counter to your guy. I had my cross-examination all worked up for him. And I was going to be able to show that, he was wrong. And I don't remember the specifics of his cross-examination, but, it's very disappointing to hear that, because, I'm thinking of justice. I'm thinking of, let's do the right thing. And you're just thinking about winning. That's it. That's what you think about. You think about winning, which I run into that in certain jurisdictions around here where I am. There are different DA offices. When you get into trial with them, you realize you're just in for winning. That's it. You're not in to seek the truth. And then let's let the cards drop where they are. Let's see what happens. Let's see what the jury thinks. Let's see what 12 people in the community think, unbiased, whether or not this person did what you say he did. And, to see the DA's office, I will not reveal their names, but they are only in for the win, period. And anyway, it's disappointing when that happens. You try to stay friendly with them because you still have other cases with them, but inside you're going, you sleaze.
Yeah. What about timing though, Robert? Why does timing matter so much when it comes to challenging these charges before the trial can happen?
Well, I think that timing, you probably want to do it closer to trial. So because, everybody has a lot of cases. And so as you get closer to trial, like I have a couple coming up, and I'm starting to, bone up for them. I'm starting to prep them. And so there's little details in every case that can, swing a case one way or the other. And so the little nuances of them as you're getting closer to trial. And so when you approach the DA's office and say, hey, look, or the U.S. Attorney's office and say, check this out, it's more on their mind. And then they also have in their mind, they have the little nuances and what you're presenting, how that will affect the case. So the timing of it, if trial is a couple months away, it's maybe not as effective. I mean, there's no hard and fast rule. I'm just saying this is kind of human nature. The closer you are to trial, the more effective or the evidence that you have will be.
How can early decisions like you were speaking about limit or expand the options for getting that case dismissed at a later point in time?
So there's a distinction here. When you say early, on a state case, you get arrested on a probable cause warrant. And then if your client bails out, then the police agency takes those reports to the DA's office to consider filing. Many, many times after that happens, then the DA, is looking over the police report. That is the time when you can make when you say early decision, that is when you can be effective. So right after somebody's getting arrested or right after somebody finds out that they are being investigated, that is my definition of an early time to talk with local authorities, the U.S. Attorney's Office or the DA's office, and get in touch with the filing person or the U.S. Attorney who's in charge of the case and let them know, by the way, have you seen this? Have you seen the evidence that I have? And that can be a difference maker because many times, and if for an example, when I think about getting to the DA early, I think about a domestic violence situation, domestic violence where wife calls police because, this is just a general example because, husband is acting up and he's drunk. And so the spouse calls just really to get the police to come in, take him away, and have him sober up somewhere, not knowing that's not what's going to happen. They're not going to take him away and sober him up. They're going to take him to jail. And once a spouse realizes that's the consequence, that's not what I want. I don't want him prosecuted. I just wanted him to just, somebody to referee this, take him away so he calms down, and I didn't want him really arrested, and I certainly didn't want him prosecuted. So between the time that person is bailed out and probably bailed out by the spouse who called the police and the time they file it, you can gather evidence from that spouse to present to the DA's office. For instance, an affidavit saying that I'm not going to prosecute and I'm not going to cooperate. It's very helpful. So those are the types of things when you say early on in the process. Certainly you can present evidence to the DA or the U.S. Attorney at any time. I'm just saying for a quicker result, quicker answer, the closer you are to the trial, you're going to get a quicker answer or a quicker response.
What should someone understand about dismissal so they don't kind of rely on false hope or those unrealistic expectations?
It depends on the kind of case. It really does. When we're talking serious cases, a homicide or a sex case, I think the sex case is the most difficult case to get dismissed before a trial, even though you have the smoking gun showing that this person's a liar. Even though you have, the person is saying, I never he raped me this one time and that was it. Even though you have a federal complaint that the person filed and that says we had sex all weekend, even after I was raped, we had sex all weekend long. I mean, you would think that would be enough to get the case dismissed, because that's a lie. You're lying to the police when you said we only had sex that one time and then I slept in the other room and couldn't wait to go home. You filed a lawsuit. You read the lawsuit before you filed it, and in the lawsuit you said you had sex all weekend long. Even that is not getting the case dismissed. Although in that matter, the DA has admitted this is not provable. Okay. I've had a DA say this is not provable. And so I understand. I'm not mad at you. We have to go to trial because you have to give that person their day in court. So when we talk about a homicide, you have a victim's family. And that means that the DA's office has to call the victim's family and give them the bad news and say, look, I'm sorry, your loved one, blah, blah, blah. Your loved one pulled out a gun. Your loved one pointed a gun. Your loved one instigated this. And so it's going to be difficult for us to prove this. So, the DA, the U.S. attorney, when the U.S. attorney has a victim, they're the lawyers for victims. And so, you can't underestimate the power of the victim and what they're saying to their lawyer, the prosecutor. I don't want you to do that. Prosecutors, they, one of the sayings in this business is that if I dismiss it or I give you a reduced charge, I don't think it's going to pass the LA Times test. Okay, so that means that, for instance, let's just talk about a domestic violence case. You dismiss that domestic violence case, and even though you're going, this is kind of violent, but she doesn't want to cooperate, you dismiss it, and then 2 years later, or whenever, 4 years later, this guy comes back and she's dead. Guess what happens? So then the LA Times comes and they find the prosecutor who did it. They'll actually try to talk to the judge. Why did you dismiss the case? Why did you only give this guy the probation? Why? And, that comes back to none other than O.J. Simpson, because everything changed, after O.J. Simpson, because he was O.J., was arrested
many times for domestic violence. Yeah,
of the same victim. And he got community service, and he, and so her pleas and her 911 calls are, would you please come this time? It is O.J. Simpson, and nothing ever happens. And so ever since then, and if you were, and I don't know if you were around then, but and know the facts of that case, but because of your age, you're like what, 25? And
no, I'm not, but go ahead.
But the reporters were tracked down, the prosecutor on the cases. Why did you let the guy go? Where's the judge? Why did you let this guy go? And that's the LA Times test. So you can't underestimate the power of the victims and their rights too. Let's just put it that way. Yep. We have a thing called, Marcy's Law, which when you resolve a case, or prosecutor resolves a case, they have to tell the victim and or the victim's family that this is what how we've decided to resolve the case. You're entitled to know that. And at the time of sentencing, you're entitled to come in and make a statement. So that's why, prosecutors are bound to inform the victims of any kind of plea negotiations and a final disposition. To give them a chance to say something to your client at the time of sentencing if they want to.
All righty. Robert, thank you for your time, sir.
All righty.
All righty, guys. That's it for today's episode of Criminal Law Unfiltered. If you or someone you care about is facing serious felony charges, understanding whether a case can be challenged early can make a critical difference. To learn more about Robert Helfend and the work he does at Helfend Law Group, visit robertmhelfend.com. Thanks for listening. Don't forget to subscribe, leave a review, and share this episode if you found it helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.